In 2011, wildlife photographer David Slater was photographing monkeys in Indonesia, and for some reason left a camera with a monkey named Naruto. Naruto grabbed the camera, took some selfies smiling into the camera, and the photos later went viral. David published the photos in a wildlife book, and the monkey sued David Slater for copyright infringement. Watch this video as we explore the interplay between non-humans and copyright law. Also, what does it take to have standing to represent animals before the federal courts? Stay to the end and I'll give you a link to a free download to my book on intellectual property. Hi, my name is Carr Ferrell. I'm a Silicon Valley intellectual property attorney. Welcome back to my channel. Naruto was a 7-year-old crested macaque monkey living in northern Indonesia when he grabbed David Slater's camera and took the famous selfies that were later published in the book. Now, for reasons that are not completely clear, PETA, People for the Ethical Treatment of Animals, decided to sue on behalf of the monkey, sue David Slater for copyright infringement. PETA told David, "You gotta pay the monkey." Reviewing briefly, copyright law protects creative works recorded in a tangible medium. Things like art and music and writing are all protectable under copyright law. Only the copyright owner has the right to display and publish and distribute the copyrighted works. And it's important to note that copyright attaches immediately upon recording in the tangible medium. It's not necessary to register your copyright until you bring a lawsuit. When you file a lawsuit, you're required under US law to record and register your copyright. The copyright infringement case was initially heard in district court and was dismissed. PETA subsequently appealed to the Ninth Circuit Court of Appeals, and the case was publicly referred to as the monkey selfies case. Now, interestingly, PETA argued in the case that they had a special next friend relationship with Naruto, and that animals like humans enjoyed the protections of the Copyright Act. In its 2018 decision, the appeals court roundly slammed PETA for claiming to be a next friend of Naruto, but rather said that Naruto was merely a pawn in PETA's own ideological goals. Furthermore, and importantly, the appeals court affirmed that neither Naruto nor any other animal has the right to sue under the Copyright Act, as the Copyright Act does not specifically say that it applies to animals. And although this may just seem like more monkey business with the court, this case really has broader implications because many have urged that artificial intelligent machines and robots should be able to take advantage of copyright law, especially where they're using their own intelligence, their pseudo-intelligence, to create works of art and independent expression. This case seems to indicate that non-humans are not protected or covered by copyright law. And in fact, there was a recent decision by the US Copyright Office in February 2022, where the Copyright Office rejected the registration of a work created by an artificial intelligent machine. So the question, can a robot or an artificial intelligent machine register a copyrighted work in the Copyright Office under the current Copyright Act? And the answer to this, based on the recent copyright decision and also the appeals court decision, the answer to this is probably no, at least not as the Copyright Act currently sits. And this raises another question with respect to patents that we're going to explore in a future video. Can an artificial intelligent machine be an inventor for purposes of the Patent Act? So one question that this raises for me is, what happens if someone hacks your phone and while you're holding the phone up to your face, they take a photograph of you and they publish the photograph on the internet? Can you claim copyright infringement and have the photograph removed? And shockingly, at least for me, the answer probably is no, because you don't own the photograph. The photographer, the person who took the photograph, that is, that that made the decision of when to take the photograph, that person actually is the photographer and therefore would own the copyright in the photograph. As I pointed out in some of my other videos, there's just a lot of strange results that come from copyright law. If you'd like to learn more, please download a copy of my book on intellectual property. I'll put a link in the comments section below. Okay, that's really all I have to say today about monkey selfies and Naruto versus Slater. If you have questions about the case or questions about copyright or intellectual property law, put them in the comments section below. I'd love to hear from you. Otherwise, I'll see you next time.